I just started to do some research, and quite frankly, I've only candidly found a case. It's in the 4th DCA, but it concerns a civil matter, and it speaks of the need for a discovery cutoff to avoid the very term I used, ambush and surprise, and that when a party conducts itself in a way as to ambush there not to get the benefit of that. These trials, we understand, life goes on beyond trials. So the evidence that can be introduced into a trial should have some finite and determinable parameters. The notion that the state comes here and asks jurors to put somebody to death suggests that they have completed an investigation that warrants that co-signing, co-signature. To suggest that, okay, there are a lot of things that we could have done and we didn't do, and if you ask about it, we're going to go do it and introduce it while the proceedings ensue, is not only an ambush, but it's an insult to the process. They're saying that they have the evidence. Now, the state can get up there and say, hey, the defense is making some ridiculous cross-examination and we don't have everything because what we have is enough, which is when they bring an indictment of this nature, of any indictment, they're saying we have enough now, beyond a reasonable doubt. But what they cannot do is, as these proceedings go forward, continue to investigate and plug holes that we reveal to exist as the process goes on until this case goes to verdict. I'm not quite sure when this would end or how there is even a gatekeeping function of the court if there is no gate and there is no fence and there are no lines and no parameters of propriety. The state is making a representation by bringing this indictment that they are ready and they have proof beyond a reasonable doubt. And if that proof beyond a reasonable doubt also includes areas of investigation that were not pursued, then they should explain to a jury why it was not pursued and why the failure to pursue it does not undermine their case. They don't get to keep plugging holes as the proceedings go forward. And so, as the Fourth Circuit said, that is ambush. And the purpose of, the Fourth DCA said that is ambush. And the purpose of a discovery deadline is to avoid surprise, avoid ambush, and a party that engages in that ought not to get the benefit of it.
Thank you.
Thank you.
Hold on.
Just briefly, I mentioned that defense isn't yet to provide any reciprocal discovery, but alluded to some yesterday that they were looking at Instagram posts and everything that had happened as recently as this week, but yet they have provided nothing to the state. So if there's any deadline of any sort that needs to be imposed on both parties.
Thank you. Oh, Counsel, my understanding is that's the way it works, is that it's not Richardson violations apply to both sides, it doesn't apply to just one side. It's deadlines apply to both sides. That's not what we're talking about.
We apologize. The pictures to say to start working. Work on it. I'm sorry.
I apologize. What I was saying is that the whatever obligations that are imposed would be applicable to both sides when there's a discovery cutoff or not. My thought is as to the discovery cutoff, you can keep investigating the case however you feel fit, and you're more than welcome to do that. However, that doesn't mean that anything you find can be used at trial as in evidence. This thing with Mr. Moretti, where when I'm out of town on vacation, you're asking the detective, or he's offering, I'm not really sure how it happened, to continue and run this through another process, and the defense doesn't know about it. The defense cross-examines Mr. Zellner, or Officer Zellner, and is not aware that he's asking questions about other programs, because his understanding is there isn't any other program. But you know there's another program, they have access to it, and they've done it, you just don't have the results. That seems to me to be what the council's talking about. And that seems to me to be a Richardson violation. There's discovery that's ongoing, you know about it, and you're not telling them about it until we're here in court. So as far as Detective Moretti is concerned, I think that's a discovery violation. And I'm finding it to be a discovery violation. I think the only way it can be cured is he's not going to testify about this second procedure that happened. That's not coming in. Same thing. If you want to keep investigating the case, you can do it. You can find exculpatory information. You may change your mind as to how you proceed with the case, and I don't have a problem. You can investigate whatever you want to investigate. But as far as using new discovery that you're coming in, I think a cutoff needs to be happened, because this is what's going on. We're going to have this. If you find something new, there's a whole, as counsel describes it, then you try to find evidence to plug up the hole that's new discovery. The defense doesn't have an opportunity to depose the witness. The defense doesn't have an opportunity to do X, Y, and Z. And that's just not the way it should be. It shouldn't be done by surprise. So
it's clear this was not a new item. This was just this, all of the information was supposed to be identical.
You found it, you had a meeting with the detective in May when we're in hiatus because I'm on vacation. All right? You had a meeting with him in May after we picked a jury, and when we're ready to, or we're in the middle of jury selection, you picked it, you did it, and you said, well, he tells you, or you ask him, do you have more programs to go ahead and provide the information, and you find out there's another program, and he runs the program, does a different download with something other than Cellbrite, and therefore you have more information. Don't make the defense aware of it. You hold that to yourself. You go ahead and put on a couple weeks of trial testimony, and then when it comes up after he in cross-examination points something out, you bring it up and say, well, by the way, I told him, the detective in our pretrial meeting, it came up and he has the program and we can use it and we're doing it, all right? And but you don't tell him about it. You just go ahead and hold it, keep it close to the vest yourself. Don't explain it to him, and then you say, when it comes up at trial, I say, what was that? I don't have the report yet. That's why I didn't turn it over to him, but didn't disclose it's coming. It seems to me that's not what's supposed to happen. Not supposed to happen, period. That's a discovery violation. Okay? So, as far as the Detective Moretti, and whatever other form he used, that's not coming in.
Okay.
All right? That's the sanction. If you have other information, other discovery that's in the works, you better share it with them, because right now, if you don't have it, they're not aware of it now. It's not coming in unless there's something extraordinary that pops up. And just because, you find out they have additional capabilities and you want to go retest something, that's not extraordinary on my way of thinking. I'm not familiar with what the case law says. It just seems to me that this is a fundamental fairness thing. You have evidence, you need to turn it over to him. If you didn't turn it over to him, you can't use it. That's really the basic.
Understood, Your Honor. And so everything has been turned over. That was the only item of which there was additional investigation done on to see if there was any other information or anything else that came out. It was reported to me that it was identical in terms of the information that was done through Gray Key versus Cellbrite on that. So defense counsel is attacking the veracity of the Cellbrite program on that. So with regards to that, that's the only reason why that would even be brought up. But if I understand there, so we can move forward on that. But I do want to address one other issue while we're outside the presence of the jury. Counsel keeps objecting to publishing of items that are already in evidence and making speaking objections. So just ask if Your Honor could address that specific issue, because the state can publish the items that are in evidence in the presentation of their case, and defense can object if there's something that has not been admitted or something to that effect. But in terms of the speaking objections and things like that, those are improper in front of the jury.
Thank you. All right, no speaking objections.
Understood.
When do you expect this documentation to come over?
I think the printer just started working.
And I provided it to Ms. Liberty.
Do you have those, Ms. Liberty?
Yes, confirmed, Judge.
All right, you ready to proceed?
Yes, Your Honor.
Defense?
Yes, sir.
Bring the jury in.